Good morning. My name is Emily Massey. I'm an attorney with Ward & Smith, for those of you I've not met. And our law firm represents Barbour's Towing. So that means that we represent the company and don't represent individual employees. And I am here to do harassment training. We've already done the employee training, and this is specifically for managers and supervisors. And it's really important to have separate training for managers and supervisors because you all have different responsibilities under the law and different responsibilities as part of your employment with Barbour's Towing. Importantly, as a manager, you set the stage for adhering to Barbour's Towing's policies, and essentially folks know kind of what to do and what not to do by following your lead. So it's important that you really understand these issues and that you follow them. So to get started, wanted to go through a few questions to just kind of demonstrate the environment that we're in today. You don't have to answer, but just think about, have you ever been involved in any capacity in a sexual or other unlawful harassment claim in the workplace? So what we talked about in the employee training, where there's a complaint about one of those protected classes. So think about whether you were the person who was harassed, or you unfortunately were the harasser, or you participated in investigation. So a lot of people say no, some people say yes. Well, do you think the typical workplace today is more aware of behavior or actions that could lead to sexual or other unlawful harassment as compared to 20 years ago? Yes or no? I think employers, yeah, I think so too. So building on that, do you think the typical workplace today is less tolerant of behavior or actions that could lead to sexual and other unlawful harassment as compared to 20 years ago? So I guess that your answers would be yes. So this last one is, despite the increased awareness and lack of tolerance for behavior or actions that could lead to sexual or other unlawful harassment, do you think the typical workplace today is more likely to have a harassment claim brought against it, or less likely as compared to 20 years ago? More likely. So that the reason for going through that is to show that harassment and discrimination has been going on for a really long time, but especially because of the Me Too movement that started a few years ago. Folks are aware of what their rights are. Unfortunately, that also means that folks don't understand what discrimination and harassment really is. Sometimes you'll see complaints where folks just maybe don't like their supervisor or feel like they're being nitpicked. That's not discrimination or harassment, but we have seen an influx in complaints. We also have seen that just because culture changes and society changes, we've seen employers be less tolerant and more aware of all of these activities, but that doesn't mean that these issues are not still happening in the workplace. They are, and also it means that complaints are going up. So it just means it's even more important that we understand how to identify these issues, how to deal with them, and how to prevent them from happening. So here are some examples of actual incidents that we don't want to see. First, a manager often begins staff meetings on a fun note by telling an off-color joke. Like I talked about in the other training, we're not saying that folks cannot tell jokes at work anymore. But as a manager, that's even more important for you to think about that. What types of comments are you making, and making sure that they are not discriminatory or perceived as harassing in any way. And thinking about different folks, different employees and their comfort level, and maybe not knowing what's going on in their life or what relationships that they have, and making sure that you're not offending them. Second example, an African American employee complains to his manager that a coworker used a racial slur in his presence. The manager responds, "Oh, don't be so thin-skinned. I've been called worse myself." That is absolutely not appropriate. If there is a racial slur in the workplace, that absolutely needs to be reported so that it can be addressed, whether it's by a customer, a vendor, a supplier, or by another employee or a supervisor. And we see this a lot, the comment of, oh, don't be so thin-skinned, I've been called worse. That's not an excuse under the law. It's either prohibited or it's not. Now, we can say someone's thin-skinned as far as receiving feedback. You know, sometimes employees aren't great about receiving feedback, and you can say, you gotta be able to take this feedback from me. But when it comes to unlawful or discriminatory or harassing comments, those are just absolutely not tolerated. It doesn't matter if it's said once or multiple times. It's absolutely not tolerated. So if someone complains, you need to take it seriously, even if it wouldn't offend you. And like I said in the earlier training, sometimes someone might complain and it ends up not being discrimination or harassment covered by Title VII, but it's still a complaint and it still needs to be taken seriously. And it might just mean that there needs to be some conversations that happen and kind of the typical HR communications that need to happen to improve the relationship. But even if you don't think this isn't a policy violation, still be receptive, still take the complaint and address it. Here's another couple examples of actual incidents. A female employee is the recipient of a client's inappropriate stares and sexual innuendos. She tells her manager, who shrugs, saying, "What can I do? He's one of our best clients." This is obviously a tough situation. No one wants to fire a client, but that in certain situations is absolutely what needs to happen. In this situation, the manager should have taken the complaint to HR, taken it to a higher up manager to address what to do with this client, because these types of sexual innuendos, if true, are inappropriate and need to be addressed with the client. Now, like I said in the other training, if it turns out after investigation, after talking to the client, that the employee was lying, well, then that employee can be disciplined for lying, including termination. Another actual incident is an employee's religious beliefs prohibit him from celebrating certain popular holidays. He is teased by his coworkers when he removes a holiday decoration from the outside of his cubicle. So this is an example of something where this might be happening with the folks that report to you. It might be happening in and around, but you may not be part of it. But if you see something like this, you hear something like this, you need to address it. You don't have to wait for someone to come complain. This person, I think in this situation did not complain, but he was ridiculed and teased because of his religious beliefs, and that's something that's not tolerated. And if you hear about it and you see it, then you need to address it. But there may be situations where someone comes to you and you don't know what to do. They complain, they say, this is going on, and you say, I don't know what to do. And so as a manager or supervisor, again, just listen to the complaint, take the information, and then take it to someone else, whether it's HR or Jerry. And then if that person is not sure, then they might contact legal counsel. Don't feel like you have to resolve everything by yourself. So all these instances, actual incidents that we've seen, all of these would violate Barbour's Towing's policies. So these are just examples that you should be on the lookout for and make sure don't happen, and obviously make sure that you don't participate in this type of conduct. Harassment is a type of discrimination that's prohibited under Title VII. The protected classes are gender, age, religion, race, national origin, color, and disability. So those are the protected classes, and then sexual harassment is a type of gender-based or sex-based harassment that's usually more associated with sexual desire. The sexual harassment, as we discussed, deals with unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And again, just as a refresher, that other unlawful harassment, it not only protects the individuals in those protected classes, but also if they have a close affiliation with anyone in those protected classes. We've talked a little bit about hostile work environment, but essentially, hostile work environment is a type of harassment. And so, what the individual might claim is that they're discriminated against to the extent that they cannot function, that they cannot do their job. And so, factors that determine if a hostile work environment exists include the frequency of the conduct, the severity of the conduct, whether the conduct is physically threatening or humiliating, whether others joined in perpetuating the conduct, whether the conduct is directed at one or more than one person, and whether the conduct interferes unreasonably with an employee's work performance. So these are a lot of factors that really, if there's a situation that comes up, it might be that one of these factors weighs heavier than another. So, for example, the frequency of the conduct. If there's something that, for example, the scenario I gave where there's inappropriate jokes made about the sexual conduct of sexual activities of women, if that happens every day, that could essentially by itself rise to the level of a hostile work environment. The severity of the conduct. If there is a something that is extremely severe, then it could be that alone, maybe with one or two other factors, could rise to the level of hostile work environment. So these are just different things to keep in mind in determining whether or not a hostile work environment exists. So remember, discriminatory, bullying, or intimidating conduct is prohibited by Barbour's towing. However, the law itself requires these certain factors to establish. So it's kind of a high bar to establish a hostile work environment. So more on hostile work environment. The environment must be both objectively hostile or abusive, meaning a reasonable person would find it hostile or abusive, and subjectively hostile or abusive, meaning the complaining employee actually believes it. And so this goes to show kind of what we were talking about with being, for employees that might be more sensitive, that you think, I wouldn't find that offensive. That's where the objective point of view comes in. It has to be something that a reasonable person would find hostile or abusive or offensive. And then subjectively means that the person has to actually be actually believe that it's abusive or offensive. Second, a hostile environment can be found from any unfavorable working conditions directed at only one protected class of people. So, for example, pervasive animosity or extreme rudeness directed only at African American employees. So we've seen this, for example, where there might be a poster or emails that go out, like the example I gave before, that are directed towards one race or one gender, and it creates an atmosphere that excludes that group of people. Again, to rise to the level of hostile work environment, has to be severe and pervasive. Has to meet a lot of those factors, but that would be something that's prohibited by Barbour's towing, and is something that if you see that happening, you should work to make sure that it stops. So why should you care as managers and supervisors about unlawful harassment? So claims of sexual and other unlawful harassment, even if ultimately disproved and not valid under the law, can cost an organization time, money, and morale. So time and money is going to take you, well, first of all, time. As a supervisor, if a complaint by an employee gets to the point where it's filed with the EEOC, or if there's a lawsuit involved, it's going to take a lot of your time. It's going to take a lot of time away from your normal job duties. And the money costs the company money, and obviously if the company costs money, that's not good for anyone. And then morale, having a lot of complaints or having litigation It's not great for morale. And also, like we talked about in the previous training, just generally, we want to make sure everyone feels comfortable. We want everyone to feel like this is a good working environment. That's why you should care and make sure that you're addressing these types of things as they come up and trying to prevent them from happening. So I have this long statement here, but it's really important that as a manager or supervisor, you are held to a higher legal standard. You represent Barbour's Towing and are an agent of the company. Your actions can be imputed to the company. So if we stop there, that's a legal term, imputed. That means essentially what you do is what Barbour's Towing does. So if you, and it's a legal concept, so it's kind of hard to visualize, but if you know about something, so if someone complains to you because you are a supervisor, under the law, that means Barbour's Towing knows about it, which seems a little bit unfair. You know, how does Barbour's Towing, how does a company, well, a company is not a person. A company cannot have knowledge. So the law has to assign to someone, you know, at what point does a company have notice that something's going on, or who has ultimate responsibility? Well, the law assigns that to managers and supervisors of a company. So that can include managers and supervisors, you know, mid-level or executive level, but the law looks at them pretty much the same. And so that what that means is that, like I say, heavy is the head that wears the crown. You have been given responsibilities as a manager and supervisor, and so part of your job duties is to really enforce these policies and make sure that you're taking complaints seriously and making sure that they're properly addressed. So moving on to the second part of the statement, that Barbour's Towing is invested in you as a leader, and you in turn must be invested in Barbour's Towing. You are expected to uphold Barbour's Towing standards and policies to the highest extent possible. So I think that's pretty self-explanatory. But I think another important point to make is that you can be a great defense or a harmful weapon. If someone complains about something, if you've kept great documentation, which we'll talk about, then you can serve as a great defense. If you heard about a complaint and didn't say anything about it, then you're a harmful weapon, because essentially that means Barbour's Towing's hands are tied, and now the company knew about this complaint and didn't do anything about it. So as soon as you hear about something or see something going on, you need to bring it up with management. So you can help the company by adhering to company policies, reporting any complaints, and documenting as appropriate. And I think it goes without saying that we also do not want you to be participating in the harassing conduct. All of the principles that we talked about in the first training about prohibited conduct absolutely apply to you. And it's really important that you're not the one participating in the harassment. So here are some more recent facts. Most of these have to do with sexual harassment, but it gives a flavor for, in general, the types of claims that we're seeing. In 2018, charges filed with the EEOC, the federal agency that governs Title VII, alleging sexual harassment increased by 13.6% over 2017, which is a really significant increase from our perspective. It's never really been that high. For charges alleging harassment, reasonable cause findings increased by 23.6% in 2018. So that means the EEOC, so if someone filed a complaint with the EEOC about discrimination, harassment, the EEOC found significantly more times that there was a reasonable cause to believe that this harassment did occur, and that means liability for the company. Third, the EEOC successfully conciliated 498 charges alleging harassment, a 43% increase over 2017. That's almost 50%, which is unheard of. And conciliation is a process unique to the EEOC. That's essentially it's the last procedure that happens before the EEOC is going to file a lawsuit potentially against an employer, and it's their process where they say, all right, we think that they found reasonable cause, we're going to need you to settle this, or else we might potentially sue you. So it's a serious event that happens and pretty much always results in a payout of money of some sort. And so the fact that it increased by almost 50% is really significant. And finally, the EEOC recovered nearly $70 million for victims of sexual harassment in 2018, which is, I'm not great at math, but almost double, maybe up 2/3. And so that's a lot. And it just shows, there's a lot of things that go into this. Like I said, more people are filing complaints. The EEOC is also very aggressive right now. They're investigating. They're increasing the amount of reasonable cause findings, and so that just means we have to be even more diligent. We talked before about reasonable care, and I said it before, but essentially what the law requires of employers is you have to take reasonable care to prevent discrimination and harassment from happening in the workplace. And so how do we do that? How does an employer, like I said, an employer is an entity, it's not one person. So how do we do this when we can't really control everything that's going on? So what we can do is have policies and procedures that prohibit sexual and other types of unlawful harassment, and Barbour's Towing has that. And then we also have a mechanism for receiving and addressing employee complaints of harassment. We also have that. And then we have these trainings, and that's why you're here today. And this will help protect Barbour's Towing from liability, and is an affirmative defense in saying, hey, we know, so if something does happen, and we did everything that we could to prevent it from happening, and these are the steps that we took to try to prevent it. The EEOC provides guidelines of what a policy should contain. Barbour's Towing's policy contains all of this, but this is just to point out to you the reason why we have that policy and why it includes the information it does. So first, the policy should have a clear explanation of prohibited conduct, and we talked about that. It's clearly prohibited, cannot discriminate or harass employees or customers or vendors based on those protected classes. Second, an assurance that employees who make complaints of harassment or provide information related to such complaints will be protected against retaliation. And that's very important because as managers and supervisors, you may not realize that some of your actions could be considered retaliation. So it's very important that as soon as someone makes a complaint, it does not matter what the complaint is, that you, from there on out, are very cognizant of the decisions that you're making. For example, if there's a discipline or suspension or even termination, that employee could claim this is retaliation because I filed a complaint. Now, sometimes it's necessary, and we see that a lot, where an employee is a really poor performer. But as long as you document, and the next several slides will really hammer that home, that documenting is so important. Documenting poor performance, documenting conversations you have with employees, documenting complaints and things like that is really important, because if it does unfortunately occur that someone files a complaint and then a few days later we gotta terminate them, they've violated our policies, they've done something really terrible. If you've documented the whole process, you can then say, hey, this is why we're terminating them, not because they filed a complaint. So the policy, so I went off topic a little bit there, but we're still talking about what the policy should contain according to the EEOC. Third, a clearly described complaint process that provides accessible and alternative avenues of complaint. And so here, the policy says that employees can complain to their supervisors or to HR or to Jerry directly. So there's alternative avenues for employees to complain. And for you as supervisors, if you need to complain about something, you just go to Jerry. Next is assurance that the employer will protect the confidentiality of harassment complaints to the extent possible. So it's pretty much impossible to keep a complaint 100% confidential. But for you as managers and supervisors, it's really important that you do not talk about the complaint with anyone else except for in your role in the investigative process. Because we want folks to feel comfortable coming to us. We want folks to feel comfortable with making complaints, and if you go and talk about it, then you're breaching their trust, and it's our policy that we're going to protect it to the extent possible. So you could be disciplined for breaching that confidentiality. So if someone asks you about it, hey, what's going on with this or that, say, oh, I can't talk about it. It's confidential employee information. But to the extent that you can, during the investigation, if you're involved in an investigation, obviously you might have to kind of say, okay, well, so-and-so alleged this, what's your response? So it's some aspects of the complaint will come out a little bit, but otherwise try to keep it as confidential as possible. Next, the policy should contain a complaint process that provides prompt, thorough, and impartial investigations. And so that's part of the policy, and a lot of times folks say, well, what's the timeline and what's the exact process? Well, every complaint is different. And so it might be that, that Jerry asks someone to conduct an investigation, and they do that, let's talk to these folks and let's document what they say and get to the bottom of this complaint. It might be that Jerry asks someone else, a third party, to come in to do the investigation, so that might take a little bit more time. But either way, it's going to be handled in a timely fashion. It's going to be thorough. And so finally, the policy should contain assurance that the employer will take immediate and appropriate corrective action when it determines that harassment occurred. Again, we don't have a rigid system of, okay, if this occurs, then they get a written warning. If this occurs, it's more of depending on the severity of the conduct, depending on whether or not it violated one of the company's policies, that will dictate what type of discipline happens, but immediate termination is certainly possible. Okay, so once the policy is adopted, the EEOC states that employers should take measures to implement and enforce the policy and take other reasonable steps to prevent and correct harassment. So, reasonable steps include the use of periodic, ongoing training for employees, and most important, supervisors and managers. So policy implementation is where you come in. We have this policy, we have this piece of paper, it's in the handbook, folks have received it, but you guys are the ones that really help us to implement and enforce it. So you are the eyes and ears of the organization. You hear things, you see things, people confide in you. And so that's where we really need you to be on the lookout. And so if you see something that's violating a policy, especially harassment or discrimination, you need to bring it up to Jerry and figure out what steps need to be taken. Where you also come in is receiving complaints. Like we said, our policy says that you can pretty much go to anyone to complain. So even if someone who doesn't report directly to you comes to you with a complaint, be receptive. Don't say, oh, not my lane. Get out of my lane. I only supervise these folks. We want individuals to feel comfortable in complaining. It might be they don't feel comfortable complaining to their supervisor for whatever reason. So we want you to be receptive to that. It might be that then you take that complaint and you give it to that supervisor, or you give it to Jerry or HR, but you need to be receptive when someone comes to you, nevertheless. If you're asked to keep something confidential, be sure to say that you may have an obligation to report it to HR or to Jerry, but that you will keep it as confidential as possible. So some conversations are okay to keep private, but my rule of thumb, unfortunately, and it's a little bit awkward, but my rule of thumb is if someone comes to you, an employee, and says, hey, I want to talk to you about something, but I want you to keep it a secret. My rule of thumb is to say, okay, I'm happy to talk, but I want to let you know that because I'm a manager, I might have, depending on what we talk about, I might have to tell Jerry about it. It seems overly cautious, but a lot of times, folks just start talking and start telling you things, and you're red flags are going off, and at that point you've told them you're going to keep it confidential, but you can't, you know you have an obligation. So my rule of thumb is if someone, again, someone who works here says, hey, I'm going to tell you something, can you keep it a secret? Say, I might be able to keep it confidential, but I might not be able to. So just really make sure that if someone asks you to keep something confidential, you kind of have that conversation. And then if they do disclose something that's a policy violation, especially discrimination or harassment, you have to bring it up. So let's talk about duties of Barbour's towing managers and supervisors. First of all, take all complaints seriously. No matter what the complaint, thank the employee for expressing his or her concern. Remain calm, unbiased, open-minded, and gather facts. Second, when you learn of discrimination or harassment, immediately report the issue or complaint to HR, Jerry, or any member of management. Like you're not on an island. You don't have to deal with these issues yourself. And actually, we really want you to involve someone else immediately, especially if it's harassment. Also, we really need you to understand Barbour's Towing's policies. So if you haven't looked at the handbook in a while, take a look. Make sure you understand the policies that you and your employees are subject to, especially the harassment and especially the unlawful harassment policy. Next, document unacceptable behavior. This is really important. So we say here, document unacceptable behavior because of the scenario I gave before, where we want to make sure that, for example, someone's terminated and they had just filed a complaint. If their record is crystal clean, they've never been written up, they've never been disciplined whatsoever, all they're left with is, well, I must have been fired because I complained. So we don't want that. I mean, we want open communication. We want employees to know where they stand, if they're performing well or not performing well. But also we need some evidence of that. I mean, for legal reasons, we need evidence of that. Also, we have short memories. And so there becomes a lot of he said, she said. Well, remember you were late those few times. No, I don't remember that. So what we recommend a lot of times, because email, this is one of the benefits of email, is that an email has a timestamp. So if you open an email, whether on your phone or on your computer, and you send it to yourself and type just a little note and you send it to yourself, it has a timestamp on it. So then you can print out that email and put it in the employee's file, and it has a timestamp. Of course, you can also just type a Word document or a handwritten note, but in that circumstance, just make sure you date stamp it, say what the date and time is, that you're the one writing it, and then write the note. But a lot of times in the moment we forget about that, so then later on we're looking in the employee's file and we see a piece of paper, we don't know when this memo was written or who it was written by. So that's why a lot of times the email is a quick, easy way it says from Emily Massey and it has the timestamp. So we really encourage that, especially when it comes to documenting unacceptable behavior. As something as small as the employee violated our policy on using profanity in front of a customer. I had a verbal conversation with him about it. Send yourself a quick email. It's part of the file. Because then if it ends up that there's multiple policy violations and it leads to termination, you have all those reasons. You can show that. You can remind the employee of that. And then we don't run into the messy situations where if that person did make a complaint and they try to claim that they were terminated for a reason not related to their performance. Finally, do not retaliate in any way. Like I said before, you have to make sure that you're treating all of your employees the same way. You can't show favoritism or preference. And that especially applies when an employee makes a complaint or participates in the complaint process through an investigation. It might be that you hear about something that they said through an investigation and you're not happy about it. well, you cannot treat them any differently. That is considered retaliation, and that's strictly prohibited by Barbour's Towing under its policies, but also could really get Barbour's Towing into trouble from a liability and legal perspective, because like I said, you are an agent of the company, and if you retaliate, even in a subtle way, against your employee, then they can claim retaliation against the company as a whole. Be alert, be receptive, communicate, whether that's with your employees or with each other and with Jerry. Document everything. Be consistent. Again, if you, an example of this we see a lot of times is employees requesting time off. So employee A is a male, employee B is a female. Employee A asks off and you grant the request. Employee B asks off and you deny it. Well, employee B is a female. She says, well, maybe it's because of my gender. Or employee A just filed a complaint about something, and oh, well, maybe they're not granting my time off request because I filed a complaint. So you need to be consistent. It might be you had a perfectly valid reason for not, but make sure that you communicate that. I mean, that might not be a circumstance that you have to document, so be consistent is one of the kind of exceptions to the document, where there are things that you do every day that you're not going to document. For example, perhaps granting someone time off. But that's just where you as a manager have to make sure that the way that you're following processes and procedures are consistent, and that you're treating employees consistently so that these issues don't come up. But if an employee does come to you and say, hey, you gave employee A time off and not me, why'd you do that? I would document that. I would certainly type yourself an email and say, so-and-so came to me upset about not getting time off. I told her it was because we had a scheduling conflict. If she wanted to take another day off, she could. I granted employee A's request because we had plenty of people to work that day. So that you have that, so that if later she tries to claim there was a different reason, then you have that in writing. Another duty is to seek help. Like I said, unless you are 100% sure about how to handle a situation, get help from each other, get help from Jerry. Managing people is really, really difficult, and so don't feel like you have to do it on your own. Treat each other with respect, be a role model for your employees, treat managers with respect, don't talk down about each other, try to encourage collaboration and treating each other kindly. And finally, carry yourself in a professional and courteous manner. Again, that will make sure that everyone else does. That covers all of the duties that we see in relation to these issues. And I know this is in addition to all of the other things that you have to do, but it's really important that you pay attention to these issues in the workplace. I want to go through a few examples, and these are actual scenarios that have come up. An Arab and Muslim mechanic was regularly called Taliban, Al-Qaeda, Bin Laden, and terrorist by his coworkers. Managers witnessed some of the comments. The mechanic complained to management, but the comments continued. The EEOC sued the employer and the parties settled. What was the employer required to do? A, pay the employee more than $20,000. B, provide training to its managers on how to respond to complaints of harassment. C, submit periodic reports to the EEOC. D, post notices at its facilities regarding the settlement. Or E, all of the above. So this is just an example of what the effect of these types of situations can cause. And I think it provides a good example of a few things we've talked about. First of all, the discrimination is based on his national origin and his religion. So obviously two issues. They were offensive comments that were offensive to him. Managers witnessed some of these comments. So that by itself means the manager should have addressed it. The manager should have pulled the group aside or pulled them aside individually and said, hey, Remember our policy, you cannot say things that are offensive about someone's national origin or about their religion. You got to stop. Document that you had that conversation and let them know, depending on how you choose to discipline them, whether it's a verbal warning, a written warning, suspension, but let them know, here's the disciplinary action, and if it happens again, there'll be more disciplinary action and potentially termination. The second issue is and also because the managers witnessed some of the comments, automatically that company had knowledge. So even if the president or the CEO of the company knew nothing about this, because the managers witnessed some of it, the employer was on notice. So the other part of this that's important is the mechanic complained to management, but the comments continued. So I think, if I recall this particular case correctly, is that there wasn't any action taken. There was no investigation. There was no pulling these folks and saying, hey, you have to stop. So that's why the comments continued. And if the comments continued too, even if they had pulled them aside and they continued, then the employer has an obligation to terminate. If they're not taking reasonable care to prevent this from happening, if it keeps continuing, even though you have taken disciplinary measures, then the employer has an obligation to take more steps. Okay, so here's our next scenario. Ken is the oldest person who works for a company. He refers to himself as elder statesman and father time. Ken exceeds expectations on his annual reviews and has no disciplinary write-ups in his personnel file. The younger coworkers ask him on a regular basis about his retirement plans and repeat the nicknames that Ken calls himself. The company is about to go through a reduction in force, so layoffs. Management knows that Ken cannot keep going at his current pace much longer, but he has not shown any signs of slowing down yet. If the company decides it wants to move in a more youthful direction because it feels Ken's best years are behind him, should the company, be concerned about a potential age discrimination claim? A, yes, because it has no reason other than Ken's age to include him in the reduction in force. B, no, because it is likely that Ken's performance will diminish in the near future. C, yes, because the younger folks call him elder statesman and father time. And D, no, because he calls himself elder statesman and father time. What do you think? Yep, A. So this goes back to what we talked about you cannot make employment decisions based on one of the protected categories, and age is a protected category. And that there's nothing in the facts that suggests that there's any other reason to terminate him other than his age. And so what's interesting about this is that he calls himself elder statesman and father time, and this kind of goes to the, oh, well, he calls himself that, we can call him that. And that's an interesting conversation, because if he's welcoming the jokes, then it might be appropriate, but at the end of the day, it doesn't mean that employment decisions that you make can be based on age or based on these different categories. Our next one has to do with Sally. Sally confides in you that the owner of the company hugged her and kissed her on the cheek at a recent office holiday party. She says she thinks it was harmless, but that it still made her feel uncomfortable. She is very reluctant to make a big deal about it, so she asked you to keep it confidential. What should you do? This is the confidential scenario where, unfortunately, and in the situation, she says, oh no, I'm so embarrassed and I don't want you to say anything. But unfortunately, as a manager, because you have knowledge of that, now the company has knowledge. And it might be that nothing else happens and everything turns out okay, but really we just can't take that risk. And so you have to say something, whether it's to HR or to someone in management, so that you can take the appropriate steps. And again, that would be a tough situation, since it's the owner of the company, and so there would likely be different approaches to how to deal with this. But nevertheless, it has to be addressed. There has to be some type of investigation to make sure that there's no other inappropriate conduct going on. If it was an isolated incident, then it can be addressed. Everyone goes on happy. Sally's not retaliated against, and nothing happens again. Or if it goes unsaid, if the manager, you, do not say anything, and then, at the next holiday event, it becomes worse, and there is more overt even worse sexual harassment, then the company is going to be liable because the company had notice of it through the manager and didn't do anything about it. So that's why we have to address these complaints or these issues, even if it's not a complaint, just these issues as soon as they come up. So this is just a visual way as we wrap up to kind of show the process of what if someone complains about harassment. So first, supervisors must immediately report the complaint to the appropriate contact within the organization. So here that would be HR or Jerry. Second, conduct a prompt, thorough, and impartial investigation. Again, that's going to depend on the situation, and Jerry will help determine how that will happen, but the investigation will occur. Protect the confidentiality of harassment complaints to the extent possible. Like we said, make sure you don't talk to anyone about it unless it's part of the investigation. Take immediate and appropriate corrective action if investigation reveals that harassment has occurred. And finally, document the entire process. So from beginning to end, all of these steps need to be very well documented. And a conversation that we will likely have if this happens is attorney-client privilege. And so if communications between a company and the attorney are privileged, meaning that they cannot be obtained through discovery. So in a legal action, a court or an opposing party's lawyer can request certain documents that are relevant. So send me all the emails that you had with this person who's complaining. Well, if you had any emails with the attorney with your attorney for the purpose of seeking advice. So if Jerry emailed me about, hey, we have this situation with this complaint, we're seeking advice on how to handle it. All of those communications are not discoverable, cannot be released to the other side. And so when we're documenting the process, that's something to keep in mind, and something we can talk about with investigations, that there might be certain things that we want to have an attorney involved so that it can be privileged and so that it's not discoverable. But either way, when you're documenting something, you do have to keep in mind that it could, and I'm a lawyer, so I have to think about the worst case scenario, but whenever you're documenting something for an employee's personnel file, you have to think, what if a judge saw this? What if an attorney who's against me saw this? Because that's essentially what happens if the worst case scenario happens and an employment-related lawsuit occurs. So keep that in mind. So your notes should be objective and should be factual and things like that. But keep that in mind, not to insert, irrelevant remarks or personal comments that are not relevant to the matter at hand. But in certain circumstances, we might decide to have an attorney involved in the investigation so that some of this documentation process can be privileged.